Your Honor, the next matter before the court is Barnstable docket number 2672 CV00125, Jennifer McCabe et al. Versus Karen and Aidan et al. Counsel, if you could please step forward and state your name for the record. You can start with the plaintiffs.
Good afternoon, Your Honor. Jim Tuxbury on behalf of the plaintiffs, Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert.
Good afternoon, Attorney Tuxbury.
Good afternoon, Your Honor. Chris Maddy. I have an application for Pro Hoc Vice admission pending, also on behalf of the plaintiffs.
Okay, so, for the defendant.
Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Jeffrey Pyle on behalf of defendant Aidan Kearney.
Good afternoon. So, there's 3 pending motions for admission Pro Hoc Vice for Attorney Murphy and Attorney Matei, is that how you say it?
Matty.
Matty?
Yes, sir.
Thank you. And for Attorney Bederow. So they were either all assented to or there was no objection to any of them. Is that correct? Anyone want to be heard any further on any of these? Okay, so I'll allow those motions. The one for Attorney Murphy is paper number 15, Clerk Donovan. The one for Attorney Matty is paper 16, and the one for Attorney Bederow is paper 17. So those will all be allowed.
Thank you, Your Honor.
So, Attorney Tuxbury, the complaint that was filed,
Yes.
a lot of pages, nothing wrong with that, a lot of footnotes, about 60 of them,
Yes.
with links referenced therein, which is helpful, so you can click on finding them usually, but it's not great for establishing a record.
Okay.
So, at some point in the future, if you could have all of those links and all those documents that are referenced put on a thumb drive,
Of course.
so that the court will have a record of it.
Yes, we can do that. We figure it's better to link them than quote them because they're quite lengthy at times. So certainly do that.
No, I get it. So we're here on a Rule 16 conference, and I'm going to have the court officer give you a copy of the rule just so we can all make sure we're on the same page of what we're doing here. And one of the goals of a Rule 16 conference can be to try and avoid lengthy litigation and reduce costs for the parties. So that's one thing I think we want to do here. Rule 16, as you all know, has 11 items that are listed to be covered at a Rule 16 conference. I'm going to take a wild guess, and I bet 8, 9, and 10 really aren't worth talking about. So unless someone disagrees with me, we won't talk about those issues, okay? But we will talk about the other ones, and one of them is simplification of the issues. Now, as I said, it's a long complaint. There's 14 counts, but when you cut through it all, there's the defamation claim, there's the intentional infliction of emotional distress, there's the negligent infliction of emotional distress, civil conspiracy, and then the 93A against Mr. Kearney alone. And because when you file it, the forms on the civil action cover sheet don't allow you to provide a lot of information, so it says defamation. And it went automatically to an average track. And under an average track, this case could last or go on for well over 3 years, which I don't think is really necessary. I think it's probably better suited to a fast track, which would get the case done in about 2 years. So, does anyone have any issue with that?
Plaintiffs agree with that assessment.
That is fine with the defense, Judge.
I'm not sure that Mr. Kearney would agree with that, Your Honor, for a couple of reasons.
Well, you're here for Mr. Kearney, so tell me why.
The likely schedule of this case, and we can talk about that, although I'm not sure it falls under Rule 16 exactly, is that I believe that both defendants intend to file anti-SLAPP motions to dismiss.
Well, that's great. That's allowed for under any tracking order.
And those stay discovery. And so that could put in some delay into the process already.
So
then
how much time?
requiring amendment of the tracking order down the road.
How much time do the defendants need to file their anti-SLAPP motion to dismiss?
We intend to serve ours by the end of this week. The plaintiffs may wish to amend their pleadings at some point, so we could be looking at motion practice on a motion to dismiss side for a while.
Just stick to my question if you could. You need till the end of this week.
To serve under
Okay.
90.
How much time do the plaintiffs need to respond?
They've indicated they're going to ask for an extension of pages to 30 pages. We don't know the substance of their arguments yet, they just general anti-SLAPP. So we also have a reply brief due in a related federal proceeding. So under the 10-day rule, we'd ask for probably a full month to respond.
Why?
I just don't, we have a reply brief due next week, and then I just don't know what their arguments are going to be.
Well, you can pretty much guess, right, that it's a petitioning activity and
The only issue, Your Honor, is obviously under anti-SLAPP, you have the non-moving party needs to marshal evidence and facts to support it. So that's my one caveat for asking for the 30 days. And on top of that, there's an issue relating to us getting some documents. I can discuss that in a little bit, Your Honor.
what's the issue?
Sure. This case started out, we filed it in April, Your Honor. Defendant Reed served some discovery right out of the gate on us, as well as to the Norfolk County DA's office. Norfolk County DA responded and said, we've already provided you a document production in the wrongful death action, and you'll find responsive materials in that production. So I called the DA's office and said, could I have the production that you referred to in your subpoena response? And he said, sure, just send me a subpoena asking for that stuff and issue a protective order in this case. I did that. He's happy to produce it. We just need a protective order, and the protective order is the same one in the wrongful death proceedings. But so far, both defendants have objected to that, arguing no discovery should happen at all, and that therefore no protective order is necessary. So obviously, the materials in the wrongful death suit would be.
Hang on. You filed the discovery. How do you object to dealing with the issue?
Your Honor, the discovery that we propounded at the beginning of this case is completely limited to certain aspects about documents that the plaintiffs received that we were not certain where they came from. We haven't propounded actual discovery. As counsel for Mr. Kearney has represented, we also are going to be moving to dismiss under the anti-SLAPP statute. We have until June 10th, by agreement with counsel for the plaintiffs, to serve that motion. That filing of those motions automatically stays discovery.
They're not filed yet.
I understand.
So the clock is ticking. He's got to deal with the issue of the Norfolk DAs. So tell you what, why don't we come back next week and we'll talk about the issues with the protective order. So if you can get the protective order that you propose to the court, and if you have some issues, let me know what they are.
Your Honor, we've received a motion from counsel regarding the protective order. Our opposition is due today, so we'll serve that. So the court will have the motion in opposition. So that would.
Yeah, that's all, I was going to say the same thing.
So when do you want to come back next week to deal with that issue? You can't see. We have the trial. You've got to. So Friday the 5th is not a good day. So what's good for the plaintiffs?
Plans are good any day, but Friday was the one day I was going
Okay,
to be.
defendants?
I can't do Thursday. If you can do it, that's fine.
Your Honor, we'll make that work. Yes, it's fine.
Any day but Friday.
Thursday would work.
We also have our next status conference on Wednesday with Your Honor.
Right.
In the other case.
We don't want to mix the two.
Yeah, that's up to you. That's up to you, Your Honor.
Okay.
Thursday, Judge, works.
I personally may not be able to appear at all next week, but someone from my office can appear next week.
Okay. All right. So Kelsey, we'll put it on for Thursday the 4th.
Okay.
Maybe we'll put it on at 10 o'clock in the morning, okay? Does that work for everyone?
Yes, Your Honor.
Yes, Your Honor.
Great. All right, so now let's set a date for the soon-to-be-filed anti-SLAPP motions. So you're going to have everything by June 10th?
Yes.
I don't think the rule necessarily gives you 30 days.
No, I think the rule just technically gives me 10 days by default.
Right.
And so again, I expect these will be lengthy motions and the fact-intensive nature of it. And as Your Honor is familiar, this is not a new case for some parties. You know, obviously Defendant Reed has been involved with millions of pages of documents and discovered for years. We still have yet to get much of anything. So that's why I'm asking for more time. But if Your Honor says less than 30, we'll make whatever works.
Anyone working the week of 4th of July?
No, Your Honor. I'll be in Europe.
How about that other person in your office?
There's some other folks.
They're what?
I'm sorry, Your Honor?
What about the other people in your office? The one you're sending next week?
I don't know their schedules for the 4th of July, Your Honor.
I'm available the week of the 6th of July.
I'm also available that week, Your Honor.
Are we, I'm sorry, Your Honor, I may have missed something. We're discussing a hearing on the anti-SLAPP motions at that time. That would be something that I would wish to argue myself, given my expertise in that area. So I would ask that it be pushed a little bit later in July so I can get back from my vacation.
When are you coming? When are you leaving?
I'm leaving, I believe, on,
Not that I want you to air your vacation plans, everyone, but
I will be back during the week of July 13th. And I'll be around for part of the following week, the 20th and 21st.
what about the week of June 22nd? Your 10 days would give you to like the 20th.
Yeah.
We'll give you 20 days. Or the week of the, you can't be here the 29th or the 30th?
Your Honor, I believe that we leave on the 1st, if my calendar is accurate. If my calendar is not accurate, my wife will probably kill me.
You're not here to cause
I
marital
believe I'm
dispute.
around on the 29th.
And unfortunately, Your Honor, I'll be on vacation then too, that time. My wife's birthday is the 4th of July, so we tend to go away right before it. Sorry for airing that.
Really tugging at my heart.
I know. She'd kill me for saying that.
We won't ask you how old she is.
You will not get an answer from me, even if I'm compelled.
July 13th? 14th?
The 14th would be fine with us, Your Honor.
What's on that week, Kelsey? Looks clear, right?
14th is fine for us, Judge. Thank you.
And plaintiffs as well, Your Honor.
Yeah, why don't we do Monday the 13th? Well, no, do 14th. We'll do it at 2 o'clock in the afternoon. So let's
Your
go.
Honor,
Go
sorry,
ahead.
Your Honor, one housekeeping matter regarding the filing schedule of this motion. The statute provides that the motion for relief under the anti-SLAPP law has to be filed within 60 days of service of process on each defendant. My client was served, I believe, on June 21st. Based on the schedule, we may be a little bit over that timing based on the extension of time that we've received and the other side has received. I don't understand conferences with opposing counsel.
Do you
I don't
care?
understand they have any objection.
Not at all, Your Honor.
Okay,
Thank you.
all right. So number 2 on the Rule 16 list, I guess you're going to have to take a look at the motion to dismiss to see whether or not you need to amend. Do you anticipate any other need to amend?
The only other reason, no, probably in light of the motion, would probably be the biggest grounds. Obviously, since filing the complaint, we've uncovered information about additional statements, and there have been additional defamatory statements by one of the defendants since that time. And at the end of the day, how much do we need to, add to the complaint? As Your Honor already noted, it's 50 pages. So we would anticipate, perhaps in response to the motion, but it would kind of be dual purpose if we did so.
We can talk about obtaining admissions, but I doubt that's going to be too productive.
I don't think so, Judge.
Hopeful. Can try, right? Documents. There should be some talk early on about documents, both agreeing to certain documents and what you're going to object to, so we can address those issues quickly. And then that plays into number 6, about electronically stored documents. So why don't you send them what you had in the other case to start? Didn't you come up with some protocol?
We did. I am confident that we can work out a protocol right at the outset that works for this case. I'm happy to work with plaintiffs' counsel to do that. I think we all do ESI a lot, so I don't think that'll be an issue here.
Are you speaking for all 3 of you now? Or just
Speaking for these 2.
My client has not previously been involved in any of these litigations, of course, but we are happy to work with opposing counsel on that issue as well.
Okay, so hopefully you can try and agree on that before the hearing date on the anti-SLAPP motions, all right? How about number 7, claims of privilege? Given the number of allegations in the complaint involving the parties and their lawyers, I have to anticipate it's going to be an issue.
Yes, Your Honor, there is. The allegations speak to communications with counsel, so we have to work through those, and we'll be asserting the appropriate objections and asserting the Ms. Reed's rights to protect that privilege.
Right. I'm sure you will, but some of the discussions and manner in which maybe parties themselves allowed information to become public may raise some issues with those claims of privilege. So how about we start with what's in the complaint, and maybe you could work toward identifying issues you have with some of the statements in the complaint. Because ultimately we're going to have to deal with them on a statement-by-statement basis, I think.
We certainly can do that.
Okay. Good.
Yeah, I think I shared his statement. I think there'll be some complex privilege issues potentially in this case, as Your Honor alluded to, given attorneys being used and third parties involved in these statements and what they were disclosing and additional information you've learned. So, I'm amenable to teeing these issues up. Part of it, we need to kind of see what the nature of the privilege assertion ultimately is and whether or not it stands. But I think, plaintiffs are obviously agreeable to addressing those as early as possible.
Your Honor, in terms of the best way to address that so the court can adjudicate the issue, would you prefer that we submit some type of a compendium of what we think is protected, privileged, allow them to respond, and then bring it to the court's attention? How would you like us to do that?
I would welcome you working to try and agree on what you can agree on and agree on what you're going to disagree on. Okay?
Thank you.
So work that out however you want, and we'll pick a date. If you want to get some dates on the books now, because I know everyone's going to be busy, do we want to pick a date in August that we could deal with the privilege issues? You don't have to, I'm just offering it up.
I would suggest, Your Honor, and I'm going to speak for the defendants, that maybe we confer and then we can come to you with a date. It might be the easier way of doing it then, because I'm not even sure what the parameters of it will be until we have a chance to see their position and go forward. That's just my 2 cents.
I'm betting, though, that there's got to be some things you don't agree on.
Your Honor, assuredly, there's going to be areas we do agree on. It's just what are those specifically? Because privilege fights are very detailed and fact specific. So I think we need to understand what they're ultimately going to be, what the assertion's going to be. So that's why I'm just putting out there that maybe
I agree with that, Judge.
Okay.
I don't have a dog in this fight, Your Honor, I don't think.
Well, you might, right?
Well, in the sense that Mr. Kearney's lawyer is not involved in any communications alleged in the complaint, to my understanding.
No communications alleged between Mr. Kearney and his attorney?
I believe in the complaint there are not any. Obviously, there's a lot of communication between him and defendant Reed's attorneys, as outlined in there. But I can't just top of my head recall any. I don't remember him having an attorney during the course of the core of the conspiracy, the defamation that we've alleged in there. But there's nothing in the complaint, as far as I recall. So,
Okay. Does anyone anticipate any expert witnesses?
Well, the underlying lawsuit has the need for expert witnesses, so, but in terms of the claims in this case, I need to assess that, Judge. I'm not certain at this point, but,
When you say the underlying lawsuit,
well, the underlying lawsuit, the death of John O'Keefe, obviously there's a dispute about,
oh, no, I'm just talking in this case.
we need to assess that. I don't have an answer for you at the moment, Judge.
we would anticipate several experts, questions of damages, internet usage, potentially issues relating to the death of Officer O'Keefe, potentially, and part of it plays into what's the state of issue resolution by that time. So it's kind of difficult to predict looking forward, but we anticipate at the outset having several experts.
Okay. Well, I encourage you to give it some thought, because that's the purpose of Rule 16, to try and get ahead of it a little. All right? So the timing and extent of discovery. The timing, if we put this on a fast track, discovery and depositions served and non-expert depositions completed would be February 10, 2027. Attorney Tuxbury, have you given thought to how many people you think you need to depose?
Oh, we have, Your Honor. It depends. I think in this case, it's unique, Your Honor, because obviously there's been a criminal trial, there's been testimony taken, there's been grand jury testimony taken. We don't have those transcripts. We're trying to get those, but there's been that. There is a pending wrongful death lawsuit that Your Honor is overseeing. There's depositions going to be taken in that case. So I think about this case, I think about the ability to leverage for discovery purposes prior testimony. Hopefully we'll be able to do that so that people are either no need to take them because they've already been deposed, even though I wasn't there. I have information there. But we anticipate somewhere between 15 to 2 dozen is what our current estimate of what we think of witnesses would be. And in terms of timing, Your Honor, we weren't that far off from what you suggested. I think the big X factor for us is the length of time on the, how long it takes to adjudicate the anti-SLAPP motion, whether there's interlocutory appeal, but we think discovery February, mid-spring is very reasonable, but with that caveat of how long that briefing takes.
February's in the winter, though.
I don't know if that's good
You
or
don't want to
bad.
extend it already. And last I checked in that other case, there wouldn't be a lot of transcripts available at this point in time.
I believe
Maybe
only-
that's changed a little.
I believe only one, Your Honor, yes.
We're trying in that one. In terms of the number of witnesses, I generally agree with Mr. Tuxbury, but in terms of the number of witnesses and the time frame seems to be fine, depending on how the anti-SLAPP motion is.
Okay. And I know you already think it's not, your client thinks it's not enough time, but
I would suggest that it's probably not enough time, but
we're going to do our best. Okay. Anything else anyone wants to talk about?
The one thing, Your Honor, we talked about the hearing on the 14th for the anti-SLAPP motion. We hadn't talked about an opposition date for, our opposition to two motions. One will be June 10th and one will be next week. I would propose, Your Honor, if it's amenable, July 7th for responses to both.
That's fine.
All right, thank you, Your Honor.
Your Honor, would we be provided with an opportunity in the event we need to submit a reply?
As long as you get it done by the end of that week. I got to read it ahead of time. Get it done by the 10th. Does that work?
I'll be away in Europe at that time, but we'll have to do what we can.
I'm not looking to ruin your vacation, all right? So if you're saying you have someone else that can help you out deal with it, fine.
I do.
Okay, good. Any other issues from the plaintiff's perspective?
I think we've covered everything, Your Honor.
Any of the defendants?
No, Your Honor, thank you.
No, Your Honor.
All right, thanks very much.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you all. So the matter is continued to June 4th, 2026 at 10 a.m. for the hearing on the protective order. This further continues to July 14th, 2026 at 2 p.m. for the hearing on the anti-SLAPP motion. Thank you all.
And hopefully you can agree on the protective order. If you do, let us know as soon as you can so we can put something else on that day, all right?
Certainly, Your Honor.
Thank you.
Thank you, everyone.